This case starts with confusion, tension, and defiance. Defendant Joshua War stands before the court, insisting he's perfectly fine, while his lawyer pushes for a forensic evaluation. But the question is, does confidence equal competence? Keep watching, because this courtroom is about to test the limits of self-representation, legal patience, and mental health judgment.
Court does call the case, People versus Joshua War.
Trevor Mabel for the people, Your Honor.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua Wara.
All right. And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly fine.
felony. That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
All right.
Mr.
Count
Simpson.
2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. Refrain from saying anything because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent.
wanna
I said I'm
represent
representing
yourself?
myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to
I
subpoena the
do
camera
have to
footage from
advise
the mobile
you,
gas station
now
on
knowing
Main.
what the
South
charges
Main.
are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding.
At this point, the judge is treading carefully. He's heard erratic statements, but he must ensure Joshua understands the charges and potential prison time. This is standard legal protocol. If a defendant's mental state seems unstable, a competency evaluation becomes mandatory. What do you think? Should self-confidence outweigh professional concern?
I tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, and I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4. And WCC pictures and.
Sir, I have listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly fine, Mr. Simpson.
Sir. For your own
I'm not on
protection
Social
and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the thing.
I do not
I
go
have
to the forensic center.
I have to, in terms of these proceedings, make sure that you are competent and
Oh, I'm
conducting
very
no
competent, Cedric Simpson. You can tell. I'm very
Thank you, sir.
intelligent.
You
I have a
can name
GED.
that
I got a
defense
GED in
team.
2013 in 3 months.
All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to subpoena my GED from the Adult Transitions Program in 2013 at Washington Community College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way if you see I got a GED from WCC in 2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29th.
a.m. I will sign an order to.
Can you give me a PR bond, please, Judge?
I'm sorry?
Can I please, I would like to request a PR bond.
This time you can file a motion, or somebody can file a motion before the court, and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently,
Joshua refuses legal help and insists on subpoenaing everyone, from gas station cameras to hospitals and the Secretary of State. The tension's thick. His logic jumps between reality and paranoia. You can feel the courtroom holding its breath. Is this a man fighting for truth or losing control of his own narrative?
I'm leaving the public defender on the case at this point.
No, I don't want a public defender.
Evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right and come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? Y'all gonna try it.
Before we go off the record.
Y'all corrupt as hell. Y'all fucked up, people. Y'all people fucked up.
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered, either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases can supply it directly to him.
Understood.
All right. Court calls the case of the People versus Brandon Nash.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Nash. This was Mr. Mayville. Was just here. Should I go step?
A new case begins. People versus Brandon Nash. A complete shift in tone. From emotional chaos to quiet compliance. Brandon calmly pleads no contest to retail fraud. The contrast couldn't be sharper. One defendant battles the system. The next surrenders to it. Two paths, same courtroom. Which approach do you think serves better in the eyes of justice?
All right, I have before me a plea form that indicates the defendant is going to be pleading no contest to the charge of retail fraud in the second degree. The 1-year offense upon his successful plea to that charge. count 1 would be dismissed. That's the court's full understanding of the agreement.
That's completely inaccurate.
That's correct, Your Honor. And I don't know if Mr. Nash, did you say your name for the record?
Brandon Nash.
Thank
Your
you.
Honor. You're welcome.
May I have him?
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Brandon Nash.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud in the 2nd degree. That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
And sir, to the charge of retail fraud 2nd degree, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as other rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
All right. Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 254132. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Not specifically, Your Honor, but I do believe that the defendant was on parole at the time of this offense.
Sir, is that correct?
Yes.
All right.
Yes, Your Honor.
So I asked you whether or not you were on probation or parole. So you were on parole.
Here, the judge explains the no contest plea, legally the same as guilty for sentencing, but avoids admitting guilt publicly. It's a calculated move, often used to prevent civil liability. Brandon stays composed, answering, "Yes, Your Honor," to every question. Calm strategy or quiet desperation. You decide.
Your no contest plea in this case.
Yes, Your Honor.
All right. And Mr. Bernstein, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Incorrect, Your Honor. I'm not aware of anything else.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes to both, Your Honor.
All right. Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
December 10th at 9 a.m.
Just say it again.
December 10th at 9 a.m.
Nothing between those 2 dates. Then.
No.
December 10th, 2025. You said 9 a.m.
Yes.
9 a.m. That is before me. Bond in this case will continue. Thank you.
Your Honor.
Thank you, Your Honor.
Thank you. You can stop down at my probation department to start the process with them. They're on your left as you go down the hallway.
Okay, thank
Right.
you.
Thank you.
Now the case of Anderson versus Lyman brings a different kind of drama: unpaid rent, frustration, and procedural confusion. The judge tries to untangle overlapping cases while emotions rise. You can sense exhaustion in everyone's tone, lawyers, tenants, even the bench. It's not about right or wrong anymore. It's about getting closure.
This case, but I'm a bit confused about one thing. Ms. Anderson, you filed a new case for non-payment?
Yes, that was just to make sure for,
Make sure of what?
she hasn't paid, September, October, or, rent, so. I was told to file a
Did
7-day.
you put September in escrow?
No, I have not.
When are you gonna do that?
This Friday.
This Friday. And then what about October?
I'm gonna get that in as soon as possible as well. I don't have a deal.
So
I thought I was supposed to,
what?
sorry.
What did you say?
I thought I was supposed to, since she was late for rent for 3 months.
Well, if I render a decision on this case, something's gotta be done with that one because this is a non-payment also.
Yeah, it is, sir. I'm sorry.
When is that set for?
November 7th.
That's the 8:30 hearing.
Yes.
My date after that is in what?
It's
No, no, this for Tuesday. So here's what I'm gonna do. That case, have you been served on that case, ma'am? A new one
So yes,
to come to court on the 7th?
yes.
All right. I don't know why that was done, but it's now caused a bit of confusion procedure. Yes.
I thought I was supposed to when it was late. I'm sorry if I made a mistake, but
Well, there's an escrow order that's in this case. I mean, and you went through a whole hearing on this case.
yeah.
And I'm gonna render a decision, but that other case is outstanding. So what I'm gonna do is I'm gonna let that proceed on the 7th. I'm gonna adjourn this case to, my decision on this case to November 18th to allow that case to catch up because I don't want a stray case out there. You have the option if you want to, I'm still adjourning this one out to that date, but you do have the option that what you can do is you can dismiss that other case because I don't know what you would get out of that case that you wouldn't get in this case.
Can I dismiss the?
I don't have it in front of me. I don't even know
Well,
where you filed it.
Can I dismiss this case and just go with this one on the 7th? Since it's for non-payment of rent? That's what I prefer to do.
I'm not gonna relitigate this whole case.
I just
That's
want,
what you want to do.
no, I just want to do it for non-payment of rent. I can dismiss the first case and just,
Well, she's got some counterclaims. You want to just dismiss this case and just go forth on the
Might as well keep going. We've been here since June, so.
Oh, I know.
I mean, there's also an outstanding water balance of almost $1,500. So I would just rather cancel this case since I'm the plaintiff and then just go with the 7th.
Yeah.
The water bill she mentioned, she took the water bill out of my name and paid it in full.
It was due on the 6th and they said it would go on my tax bills if I didn't pay
I
it.
don't know why I'm talking about a water bill at this point.
Sir,
What do you want to do? Because you've got this thing all over the place.
I'm going to withdraw this case and just go with the 7th for non-payment of rent. She's 3 months behind right now. And the water bills,
How can she be 3 months behind? She's
September, October, and then it'll be November, and then the water bill of $1,500. So it's well over, she owes a total of $15,000, a little over 15, and she has 6,600 in escrow. So it's getting deeper and deeper. The further we delay it, the bigger the hole gets.
I'm not delaying anything. You keep doing stuff.
Well, I want to withdraw this one and just go for the 7th since I'm the plaintiff on both. For non-payment of rent, that's all I'm concerned.
No, I know. That's why I don't understand the second case.
Well, That's all I want is to.
I mean, you think I'm sitting up here and don't know anything.
Yeah.
I look stupid, but I'm,
No, you're very smart, sir.
oh, I know that.
I would just rather withdraw this case and just go on with the 7th.
You let me know when you're done talking.
Okay, sir. Thank you, sir.
Are you done?
Yeah, I mean, the other attorney
Apparently not. Go ahead.
the other attorney I was working with before suggested that I do that I withdraw this case and just do the 7-day notice. That's what he suggested. He said that would be easier.
You done?
Yes, sir.
Lyman, what would you like to do? So just so that you understand, if she dismisses this case, what I would do is I would pay the escrow over to her, okay, on this case. None of, if you dismissed it, I wouldn't be dismissing any of your claims that you have against her. I wouldn't be dismissing any of them with prejudice. You'd be able to raise them in the other one if that's what you choose to do. But that's up to you. And then you'd have to come back on the 7th and we'll see exactly where we are.
I just feel like we should just keep going because we're smart.
But
Finish it out.
since I'm the plaintiff, don't I have the right to cancel that one, listening to my counsel?
You should have gotten an attorney before you started. But
I know, but that's what he suggested I do. He said,
no, because once she's answered, she has the same right. She can say no.
okay. So if I cancel the one on the 7th, can we just be done with this today? Is that better? I just don't want to keep dragging this on. So if I just kill the one for the 7th and we just,
Ma'am, I can't give you.
well, that's what I want to do.
As to, well, I don't have that case in front of me. It hasn't even been heard. It was filed.
It was just for non-payment of rent, but since you said it overlaps this one, then let's just cancel that one and just do the non-payment of rent on
Here's
this.
what I'm gonna do. You're gonna stop talking.
Okay.
And then I'm gonna do what I was gonna do at the beginning. And that is, I'm gonna let that other case catch up. They're just gonna be together because you elected to file it. Whether, under what reasoning, I'm not even concerned about that. But I'm not gonna have two cases standing out in this situation. So I'm adjourning this case for its decision to November 18th. When we get to the other case on the 7th, I will try to have that case catch up with this case. And then we can just decide everything, unless somebody wants to file something else in the interim. Thank you.
Thank you.
What time on 18th?
9.
Are we coming on the 7th as well, sir? Okay. Thank you.
From mental health debates to quiet guilty pleas and landlord disputes, this courtroom saw every shade of conflict today. Justice isn't always loud, but it's rarely simple. What moment stood out most to you? Drop your thoughts in the comments. And if real courtroom stories like this fascinate you, like, share, and subscribe for more gripping legal moments.